countries and also between Muslim and non-Muslim countries. And underlying this, we're looking at how privacy figures in the Quran and in the teachings and traditions of the prophets. Now, we're going to be considering the impacts and significance this has for the development of law in these countries and for its regulation. And also to how these considerations interact with other legal frameworks, such as those in the EU. I'm Elizabeth Coombs, and just very briefly, I chair the United Nations Special Rapporteur on the Right to Privacy's Task Force on Privacy and Personality. I'm going to introduce the speakers, but I'm going to do that brief because I think the topic so interests me. I want to make sure that we maximise our time on that. So I urge you to have a look at the bio notes. But I will just quickly run down through them. And so starting from our first speaker, Dr. Sonny Zulhuda, Associate Professor, Faculty of Law, International Islamic University, Malaysia. Sonny has advised the Malaysian Personal Data Protection Commissioner on the implementation of the personal data protection law in Malaysia, and was also consulted by the Indonesian government on their draft data protection law. Second speaker is Nighat, and Nighat is the Executive Director of the Digital Rights Foundation in Pakistan. Nighat is a lawyer and a human rights activist. She has many acknowledgements to her name, and I won't list all of those other than to mention what I saw as the most recent one, which is her nomination as a young global leader by the World Economic Forum last year. And then to our third speaker, Laucine Anis, the Secretary General of the Moroccan Data Protection Authority, a role that Laucine has held since 2011. And now he's worked with many international organisations and is currently a member of the UN Global Pulse Advisory Group and oversees the Permanent Secretariat of the African Network of Data Protection Authorities. And our last speaker is Patrick Penninckx. Patrick works in the Council of Europe in an Information Society department under the Directorate of General Human Rights and the Rule of Law, where he coordinates standard setting and cooperation activities. His professional focus is broad, covering areas such as freedom of expression, safety of journalists, human rights on the internet, governance of the internet, international standards in data protection and cybercrime fields. So as you can see, we've got very diverse and also very well qualified people to be speaking as our panelists, but equally qualified is our moderator, Professor Andrew Adams, and amongst other roles, Andrew is the Deputy Director of the Centre for Business Information Ethics based in Japan, and his background is computer science and law. Andrew has many publications to his name, and I note in his bio it says he is interested in too many things. So I think that he's very well qualified to be our moderator today.
Okay, thank you. So we'll pretty much go straight into it, starting with Sonny's presentation. Just a note about how we'll do it. Each presenter will have about 10 minutes to give their presentation. We'll save questions for the end. I'll want to get it opened up to the audience as soon as possible, so I won't interpose my questions at that point. So I hope you all have interesting things to ask our very well qualified panel today. And over to Sonny for his presentation. Thank you.
Testing. Thank you, Andrew. Hi, everyone. My task is to first share with you the conceptions or the legal conceptions of privacy from the Islamic perspective. And of course, it's not a simple thing, but we try to see, especially we try to derive what we can get from the main source of the law in Islamic legal system, which is from the Quran. Right, you see here just a brief introduction of where I come from. This is the campus in that part of the world. Just in case you happen to be there, you are welcome. Next, about privacy in Islam. This is a general statement that we can have about the subject matter, where Islam is considered for Muslims as a way of life and a comprehensive guideline for its followers to behave and conduct their life, both in public and private. especially in public life, Islam guides Muslims on how to build and maintain relationship with people, with society, and so on. From this perspective, we see how important it is to recognize the rights of everyone, the rights of every members of society, where every individuals live, and that includes certainly the right to privacy. Then my approach here is to derive from the text of the source of the main source of the Islamic law, which is the Quran. So if you see the number 4, column 29 means in chapter 4 of the Quran, verse 29 to up to verse 30, you see this a very brief, a very general statement on the fundamental rules on the prohibition to cause aggression and injustice to others. So from this perspective, we can derive a lot of things, a lot of aspects and dimensions of what it is meant to be. And certainly it includes a lot of aspects of life, including how well you treat others, how should you behave and deal with other people's property, including other people's data for that purpose. So from this perspective, we see a very clear injunction in Islam against unjust exploitation of others, and also the importance of mutual consent. So any transactions are required as long as it is legally justifiable as well as mutually consented. The next slide. It is interesting to note that in Islam, especially in the Quran, it gives this guideline or encourages and in fact mandates people, especially parents, to start educating children about respecting others. And this is where we can derive very clearly the command about respecting privacy of others. So in these verses that I quote here, there are two things. First, the parents at home should inform their children if the children have not attained the age of puberty. So largely it's before 14 or 15 on average. So for these children, you must tell them that you must get permissions if you want to reach the parents' place or rooms. This is a domestic rule. This is a rule inside your own house. So tell them whenever you want to go to, parents' room, for example, you must get permission, especially on these 3 particular times. So this is very clear rules given in the Quran. And what are those 3 times, 3 specific durations, which are before the dawn, which is before the dawn prayer, and then towards or just at noon, and the third one is after the night prayer. Of course, these are considered 3 specific times where people, especially adults, require their own privacy. So this is very clear that for children, you have to ask permission if you go, you want to enter the parents' place, especially in these 3 occasions. But then the rule for those children which already attained puberty, the rule is more stringent that throughout the day you must ask permission. You cannot simply enter parents' rooms, or chambers without asking permission. This is for those who already attain puberty. So these are clearly this is an indication that we are educating our children right from their early childhood. And then also there are some verses which indicate the importance of protection of reputation, honor, and dignities. So in one of these verses that I mentioned here, we are not supposed to let people ridicule other people because who knows, perhaps those people that you ridicule are better than you yourselves. So what we can take from here is that you must uphold dignity and and respect to others, even if you don't know about that person. and you are supposed to control your ego as well as your self-superiority. So this is also another leading rule or leading lessons that we can use to uphold the privacy. And also in other verses of the Quran, it says that you shall not insult one another and do not call each other by offensive nicknames. So that really reminds me, you know, when it comes to processing data, we tend to put labelings, taggings, and you better be careful for not labeling people with the names that they dislike. In other verses of the Quran, also there's a very important rule of principle of information verification, especially in any time you receive information and you have some doubt, especially on the person who convey that message. So that is a clear indication that you should investigate of the accuracy of that information. So this is in order to ensure that the data is correct, is accurate, and therefore you can achieve data accuracy and data integrity, and which leads also to respecting people's privacy. And then in other parts of Quran it says that if you fail to investigate, you may reach, you may cause other people to be hurt and to be insulted. So this is what we want to avoid. And when it comes to rule against surveillance, there's a very specific item here that the Quran says that you shall not spy or backbite each other. These are two different things, but not very, not uncommon in our life. So on surveillance, it is clearly indicated that you must not do it, or you try to avoid it, especially if you don't have justifiable reasons. And then there is a very strong rule as well, and it comes to inviolability of a person's private home. Whenever you want to visit, you better get a permission, and this permission you cannot assume. It must be a very clear permission, and if you are not getting that permission, you better go back. And if the person tells you, no, sorry, you cannot come in, you better come next time, you should go back, and you must go back. So this is very clear, things put in the Quran. So it really gives the message that the home is very inviolable. It is the privacy of people, and they shall have control over it. Also in Islam, whenever you have transactions or any processing of data or anything, you better have it recorded. So recording things is a very important feature in Islamic legal transactions law, and you must have things being recorded so as you can assert the debts, obligations, rights, and also you can ensure that the other party does not repudiate whatever has been promised by within the transaction. So we do have, I just put everything in one slide here. In Malaysia, we do have some cases related to privacy, and interestingly, in one of the cases in 2010, Siwa Rasa Rahsia, the federal court says that privacy, even if the privacy right is not specifically mentioned in the constitution, but is considered as part of the right to liberty, right to life and right to personal liberty. Basically starting from right to life, which is in the constitution, and then further leading to personal liberty, and that leads to right to privacy. This is what was decided by the federal court. My time is up, so let me just give you the last slide, just for your view. I come from both countries, as I'm contributing to both countries in Malaysia and Indonesia. Malaysia already has the law on data protection law since 2010, and it is enforced now. Some prosecutions are there, but in Indonesia, I have my colleague there also, the advisor. The law is still within drafting process, and it's going to be, hopefully, to be tabled in the parliament this year. So any questions to that also are welcome. So that will be all. This is a conclusion of what I have said. 4 things, yeah?
The conclusions upon
Oh, sorry. Oh, I have these 2 things with me at the same time. Yeah, the conclusion, yes. One, in Islam, we derive from the verses that we have said. First, Islam really respects the individual privacy. Islam in general prohibits injustice and transgression to people's rights. And then we emphasize the public harmony and reconciliation, as well as, last but not least, the transparency and accountability to God, to society, as well as to yourself. So that would be all from me. Some references maybe for your benefit. Thank you.
Okay, so thank you very much, Sonny. That gives us a good introduction to the concepts of where the ideas come from in the Quran that generate the ideas of privacy and data protection that are now being or have been implemented in various countries which implement Sharia law or have a Muslim majority population. So now we're going to move on to Nighat, who's going to tell us some more about some very specific details, picking up where I think Sonny left off there. So Nighat, over to you.
Yeah, thank you. So based on what Sonny mentioned, this is evident from some of the verses of Quran. One verse which we have just read here in the presentation says, "Do not spy on one another," chapter 49, verse 12. Another verse says, "Do not enter any houses except your own homes unless you are sure of their occupants' consent." It talks about consent here very specifically. It's chapter 24, verse 27. And the Prophet Muhammad has gone to the extent of instructing his followers that a man should not enter even his own house suddenly or surreptitiously. The Prophet, according to the hadith of Amir Muawiyah, remarked, "If you try to find out the secrets of the people, then you will definitely spoil them, or at least you will bring them to the verge of ruin." And there are several references in the Quran and in Ahadith and Sunnah where the right to privacy, the dignity of person is basically admitted and is specifically mentioned. Islamic law is composed of Sharia and Fiqh. Sharia indicates the path of a faithful Muslim must undertake to attain guidance in the present world and deliverance to the next. Fiqh, the jurisprudence of Islam, refers to the rational understanding of Sharia and human reasoning to appreciate the practical implications of Islam. While Sharia is divine revelation, Fiqh is the human inference of Sharia. The Islamic Republic of Pakistan aims to be Sharia compliant as it legislates and interprets laws. Under the Pakistani constitution, there cannot be a law in violation of the injunctions of Islam, and Pakistani culture is heavily influenced by Islam, particularly after the Islamization policy enforced in the country in 1980s by a dictatorship. Cultural and Islamic values have bled into one another's in the minds of Pakistani citizens. This, in turn, creates some dominant beliefs which feed into our legislation and which are perhaps not purely Islam-based, but are also the result of connection between subcontinental culture and Islam over time. These issues apply equally to the perception of the right to privacy in Islam and its application in Pakistan. We see that often the laws which protect the right to privacy are not spoken of in terms that religion attributes to those rights. This can lead to this area of the law remaining underdeveloped, for example, the lack of personal data protection legislation in our country. Further, cultural notions of what is private and whose responsibility it is to maintain privacy also affect the enforcement of laws which are already in place. So, under the Constitution of Pakistan, Article 14 basically covers the right to privacy. It says, inviolability of dignity of men. The dignity of men and subject to law, the privacy of whom shall be inviolable. We can see that privacy is spoken of in terms of the privacy of homes, and what Sonny mentioned in several verses of Quran, that privacy of home is mentioned several times. This ties into some cultural concepts and language that have developed in Pakistan over the years. The average Pakistani person, with the way he or she has been conditioned and the values that have developed in them over time, will first think of the concept of parda. So parda means covering yourself. If they think of the right to privacy, a woman will know that it is her right to cover herself, and the law will recognize this. The rules of evidence also tells us that the woman who does parda need not appear in court in person in order to give evidence. Similarly, a parda nashin woman, a woman who observes parda is called parda nashin, will also have her right not to be photographed respected. An accommodation must be made within Pakistan where her identity needs to be ascertained. In the above examples, we can see that the woman's action are the first step in exercising this right to privacy. And unfortunately, we see that when women do not take the step of covering themselves, they are often seen as forging the right to privacy. If they are sexually harassed or assaulted, women who do not cover up are often held responsible for the crimes perpetrated against them. A similar issue arises in terms of women leaving the homes. The privacy of home is a prominent concept in Islam, and Pakistani law also protects this. Although perhaps not in Islamic terms, we see that women who leave the home without any male guardian are also seen as foregoing this right or protection. This is tied to the cultural concept of char diwari. Char diwari is 4 walls of home. Once women leave the 4 walls, they are afforded less protection. So how this interpretation lends itself to abuse or misuse when it applies to men and women? What I have seen mostly in Pakistan is that mostly lawyers, prosecutors, law enforcement agencies will shy away from pursuing domestic violence cases or disputes between families by saying it's a private matter. In an oppressive situation, be it cultural or government-induced, legislation which can include great tools, it's often misinterpreted or misused as a tool of oppression. Similarly, the cultural connotations connected to the concept of privacy in Pakistan often influence the inception and application and enforcement of laws. So there are a few things that I have observed in a couple of years since I started working on the right to privacy in the online spaces, that mostly the burden lies on individual and not on state when the laws are being made. And no law in Pakistan can be made without the approval of the Islamic Council, that is one body, Council of Islamic Ideology, which basically is the final body to approve any law passed by the parliament. This is also interesting to note that laws related to women empowerment always face resistance from Council of Islamic Ideology. It took 12 years to get a domestic violence law passed in one of the provinces in Pakistan just because of the concept of char diwari. Laws giving massive powers to the to the authorities in terms of spying on citizens, collecting their data, maintaining world's largest biometric database, creating smart and safe cities in the name of national security, always get away with the argument of national security. And that's where the concept of right to privacy, which we derive from Islamic jurisprudence, never apply on state, but always apply on individuals. Thank you.
Okay, so thank you very much for that. That gives us some very interesting variants where the Quranic principles are then adjusted or focused on or left to lie fallow, depending on the cultural context. And of course, this is something which has to be considered, that the Islamic legal conceptions of privacy vary depending on the other local cultural contexts as to where they are applied. There may be some common background to that, but what you choose to do with them will vary a great deal in different places. So we'll now move on to Lassasine.
Thank you. Good morning, everybody. First of all, I would like to say that I'm really pleased and honored to take part to this panel. I'm representing Mr. Omar Seghrouchni, who is the new chair of the Moroccan DPA. He was appointed last November by His Majesty the King. Due to some internal duties, he couldn't be among you today, and he asked me to convey you his regards and his apologies. I have to admit, though, that I found the subject of this panel very, very challenging, because of the time that I had to prepare it, a few hours, and also because the chair asked me not just to examine privacy in Islam, but also to share with you the point of view of a regulator. So after some thoughts and research, I came up with this agenda. First, I will try to compare some privacy concepts between 21st century and 7th century. Then I'm gonna say some examples who has already been mentioned by Sonny and Ada that exist from Quran, the Sunnah, which is the portion of the Islamic law which is based from the act and words of the Prophet Muhammad, and also from the Salaf, which are the portion based on the behaviors of the companions of Prophet Muhammad. Then we're going to see if the privacy rules are absolute or are there any exemptions, like in modern laws in Islam. Then what is the situation of the privacy protections within some Muslim countries. I'm going to tackle the declaration of the Islamic Conference. And finally, I'm going to share with you some indicators of the Moroccan authority regarding one rule of privacy which stems from Islam. First of all, as it has been stressed upon during the last conference of international privacy commissioners that was held last summer in Brussels, privacy is a question of ethics and human values before being a legal issue. And Islam, like other Abrahamic religions, promotes these values. Prophet Muhammad, peace be upon him, said, "I've been sent to perfect good character," which means that the purpose of him being the prophet and the messenger was to perfect the magnificence of values. To understand the extent of privacy protection in Islam, we have to put it in the right context. Is personal data in the 7th century similar to that of the 21st century? I doubt it. That's why I took the definition of personal data that exists in Gdpr and tried to see which ones didn't exist when Islam appears. For instance, there wasn't in my point of view, no identification numbers in that period, nor an online identifier. And the technology and the science wasn't enough developed in order to use genetic data. I've done the same exercise regarding the definition of processing in GDPR. And as you can see in this slide, in red, there are too many operations that exist nowadays, but are irrelevant in the 7th century. Why I have done this exercise? First, to identify personal data and its processing that existed in that period when Sharia law appeared. And also to measure how its principles, the principles of Sharia, was and are tailored to these principles during that period, as the GDPR is tailored now to the internet, big data, and so forth. According to my research, which is certainly incomplete, I identified 3 types of operations that existed in that period. First, the collection of personal data, whether by sight or by listening, disclosure of information, especially by gossip, and finally, the alteration of personal data by saying, for instance, lies and false information about others. And all this type of operations has been processed by Islam. There are some safeguards in order not to violate privacy of people. Here I'm going to share with you some examples that have been already mentioned by Sonny concerning the collection of personal data by sight. The Quran in Surah An-Nur, Light, in its verse 27, forbids entering homes, and therefore the collection of data regarding its inhabitants, if you haven't saluted them before. That is when we say saluted in the words of GDPR, if they haven't been informed that you may see them and collect their personal data that normally they protect within their houses. Moreover, in the following verse of the same surah, it is said that you shouldn't get into the house until you have permission, clear and freely given consent in the words of GDPR. And if you have been told to go back, then you should go back. This reminds me of the opt-in concept in nowadays laws, and also to the right to object to personal data processings. concerning the concept of proportionality that we know we are familiar with these days. Concept proportionality of information that can be accessed by other people. It is organized by the hierarchy of home privacy domains within a house, as illustrated in this graph. For instance, all personal information regarding women can't be accessed by male guests, and so forth for other categories of people. Concerning collection of personal data by listening, verse 12 of Surah Hujurat, the rooms, forbids spying and eavesdropping. That is, the collection of personal data from uninformed individuals and thus who haven't given their consent. With regards to the same processing operation, but of special categories of data, for instance, criminal offenses, religious beliefs, and personal sex lives. In this, Islam, through Sunnah, gives an example of strict conditions to process these informations. The Prophet Muhammad, peace be upon him, turned his face away 2 times from a man who sought to admit that he committed adultery. Only subsequent to the man's insistence on making his admission for the 3rd time, did the Prophet examine the proposition that the person's psychological condition may have induced him to make his confession. Basically, after the exclusion of these factors, that the penalty was applied and the personal data that was given by that man was considered. In Surah Hujurat, the rooms, verse 11, it's not allowed to alter individuals' personal data, as it has been said by Sonny, by using nicknames instead of names. In Surah At-Tahrim, prohibition, in verses 3 and 4, the Prophet's wives were blamed because they have disclosed some secrets that were given to them by the Prophet. So Islam is clearly against the disclosure of others' informations if you don't have their consent, even though there are some exemptions that we're going to see afterwards that as it exists in modern laws. Finally, how is privacy rules applied by enforcement agencies in Islam? Through this example, we can see that Omar ibn Khattab, which is the 2nd Caliph, while he was traveling at night in the city, heard a noise and cursing which was coming from a residential area. He tried to discover the reason for these loud voices that were coming through houses. So Ibn Khattab tried to peek into the house and said to the man who was in that residence. Actually, that man was saying he was in company with some girls and he was having some wine. You, the sinner, do you think that Allah will ignore your sins as you're sinning against him? And the man replied, if I sinned once, you sinned 3 times. Allah has forbidden you to look into someone's fault, and you have done otherwise. Allah has commanded you to enter people's homes through the front door, and you have intruded over the fence. And you have approached me without salutation, and Allah has commanded you not to enter into other people's homes without their permission and without saying greetings when you enter their premises. So, we conclude from this example that Islam, even if the government can't violate the privacy of people, even if the purpose of the processing is to enforce the law. Actually, there are some safeguards and some conditions that should apply. As I mentioned before, there are some exceptions to the disclosure of secrets in Sharia and Islam law. First, to protect one's and defend one's right before the judge, and also to report some categories of crimes. These are the exceptions, so it isn't an absolute right. What about current frameworks in countries where there is majority of Muslims. The Islamic Conference, which is composed of these countries, adopted in 1990 in Cairo declarations that guarantees the right to privacy to individuals, as it can be seen in this extract of the declarations that you can see in this slide. And finally, as I said, I'm going to share with you some indicators of our authority, the Moroccan DPA, regarding the enforcement of a rule that stems from Islam, which is privacy of home. As you can see, we have received many numbers concerning the use of CCTV that was filed by neighbors who thought that there was a violation of their privacy by their neighbors using the CCTVs. And also, concerning the investigations that are performed by our investigators, the on-site investigations that are performed by our authority are a total of 152. 95 of them concerns the use of CCTV in homes. And so far, we have transferred 8 cases related to the use of CCTVs by neighbors to the courts in order to apply sanctions. And we have performed 1 seizure of CCTV equipment that violates the privacy of neighbors. Thank you.
Okay, thank you. So that gives us 3, well, 4 if we count Indonesia as well as Malaysia, 4 different examples where the specifics of Islamic countries are implementing some of these. So now we're going to move on to how this fits in to the growing international consensus and the international issues of how you try and get countries with different cultural backgrounds and different legal systems to come to agreement on common rules of privacy and data protection. So we have Patrick from the Council of Europe who's going to give us a talk about some of those aspects. Thank you. Patrick, over to you.
Thank you. Thank you so much. I'll try to take a little bit a step backward, because obviously we have here had a very good analysis of what the Quran says about privacy, so I have no need to go into that. I will take it more from a more pragmatic point of view, if I may. That is, first of all, we all agree, I believe, that data flows are increasingly international. They have no boundaries, and it is difficult for a number of countries that want to prevent themselves from such global data flows. It is increasingly difficult to do so, and it's only very few countries with very high investment that manage to do so. So that is something that we have to already take into account. Secondly, I think our starting point has always been privacy is one part of the fundamental human rights. And that is basically why within the Council of Europe we have a data protection convention which was recently modernized. Why is that so? For the simple reason that privacy is one of the cornerstones of human rights. And in this current context, in the developments that we have with data, big data, artificial intelligence, etc., this becomes increasingly important. And I think it is also important that we provide for a common legal space worldwide that allows us to do so. Third element, of course, and because the panel does not only speak about the interpretation of Quran, but also speaks about the different Muslim countries. Muslim countries are very diverse. We've had a couple of examples here, but there's quite a number of other countries, and I would not only speak about countries with a Muslim majority, but also increasingly so, big, especially in Europe, an increasing number of countries with big Muslim minorities, which also has an impact on how we perceive privacy, and I will speak in a few words about that as well. Why, if I I'll say a few words about Convention 108. Why? Because, in fact, Convention 108, we have to see it in a global context. Right now, we have about 133 countries, if we look at the last count, that have started to develop data protection legislation. That means that there is a common concern, a growing common concern. 2/3 of the world countries have a data protection legislation. We need a common tool, and that common tool for us is obviously Convention 108 and Convention 108 Plus, which is unique. It's the only internationally, legally binding instrument in this field, and it will be for a long time to come. It is open, that's also important. Any country in the world with a complying data protection legislation can request an invitation to accede, and we have a number of countries like that. It's also influential because its basic principles, despite the diversity of political regimes or cultural or religious backgrounds, a number of the principles contained in there will influence national legislation independent of whether a country is predominantly Muslim or not. So it's difficult to talk about Islamic countries in general because their geographical and cultural differences in respect of data protection legislation, there is not necessarily a link between Islam and the level of protection afforded by the countries. The level of data protection legislation might be more correlated to developments such as economic and technical rather than religious elements. There's no incompatibility between what we see Islam and Convention 108. This can be demonstrated by the fact that a number of countries with a significant proportion of Muslim populations who have already ratified the convention and applied in Europe, such as Albania, Bosnia, Turkey, Tunisia and Senegal as non-member states of the Council of Europe have also acceded to Convention 108 in 2017. Morocco and Burkina Faso right now are non-member states in the process of accession to the convention. So this gives you a bit of a global picture of where we are, and I should superpose it with the countries of primarily Islamic majority. Turkey is one of the countries with such Muslim majority that has enacted a data protection law. It ratified Convention 108 in 2016. The main piece of legislation covering data protection in Turkey is the law on the protection of personal data, and the Turkish Data Protection Board is responsible for the enforcement of the Turkish law. So although the Turkish constitution established a general right to privacy, and there's a patchwork of personal data protection provisions contained with specific sector specific regulations, this global law represents Turkey's first dedicated privacy and protection statute. So we have a number of examples there within the so-called within the Convention 108, covered by Convention 108, of the 53 countries which are currently bound by the Convention, Albania, Azerbaijan, Bosnia and Herzegovina, Turkey are Muslim majority countries which are already bound by the Convention. Senegal, Tunisia are also bound by it, and pending are, for the Muslim countries, Burkina Faso and Morocco. But we also have a number of observers like the Abu Dhabi Global Market Registration Authority, Indonesia, which is an observer. So we're talking about nearly 70 countries. So when we're speaking about Islamic jurisprudence, which ascribes to the idea of public and private sphere, the respect of private space, and as we've seen in the past three presentations, the respect of private space as a family life is highly protected, free from any interference from the outside. On the other hand, the public sphere is occupied by society and governmental action, including scrutiny and observation. However, the last decade's increase in information exchange through the internet, not only, but also social networks. I think in some of the North African and Middle East countries, the presence of social media is much higher than any other part of the world. So let's also take that into account. And that has, when we speak about the Arab Spring, for example, and the revolutions that took place in Egypt and so on and so forth, we know that there has been an enormous input from the internet. That also basically means that these last decades, through this information exchange, the strict distinction that you have described between the public and the private sphere is getting more and more blurred. Let's face it, that is the reality. By other words, data protection regulation as such is not so much affected by the idea of a public and private sphere. We can debate this, of course. So it may, however, also be interesting to note that we may have a couple of concerns to what is called sensitive data. And that it may apply to some Muslim countries. For example, to which extent, and ironically I would say, to which extent do we consider religious belief as to being sensitive data? In Europe, this would definitely be sensitive data. So there we may enter into a certain reflection that we need to deepen a little bit more. And another point of tension relates to personal data concerning sexual life. For instance, if I may use the example of Morocco, the Consultative Committee of Convention 108 noted in 2012 already that the Moroccan legislation as an overall conformity with the principles of Convention 108, with the exception of the definition of special categories of data, since in the Moroccan legislation there is no reference to personal data concerning the data subject's sexual life in the categories of sensitive data. Is that because we make this clear distinction between private sphere and public sphere? Obviously, in the developments that we now know, also concerning sexual orientation, etc., these are key concerns. And we have to really consider what we consider. Also in countries which have, let's say, predominantly Muslim majority in their countries, to which extent do we use, and that was my starting point, these human rights principles as the safeguards and first and foremost important aspect. I will also say a few words later on about the Sharia councils and how they may affect also the question of privacy, namely in countries such as Great Britain, where there's quite a great number of Sharia councils which decide on family matters, to which extent this will interfere with legislation concerning data protection. So in the past 2 years, there's been an enormous increase in data privacy laws to, as I said, currently 133 countries. I forgot to push these buttons, but I'll come back to that afterwards. So we've seen an enormous increase with countries planning to enact such laws, and the bills to strengthen existing laws all underline the continuing global expansion of data protection laws. The expansion of Convention 108 beyond Europe is now evidenced in agreement on the fact that it's the only viable global data privacy framework, and that is increasingly being acknowledged. I see my good friend from Argentina in the room, that he will certainly be able to advocate how data protection is a very current issue in the whole of Latin America, and how the Convention 108 is one of the prime landmarks there. So the convention is also there to accommodate all types of legal systems which are in compliance with the principles of the convention, including Muslim countries. And I think privacy matters, if I may use that, Pat, is increasingly and predominantly, independently of any Muslim majority or minority or Buddhist majority or minority, an increasingly important feature for us all. That's probably why the Special Rapporteur on the Right to Privacy recommended very recently that the UN member states be encouraged to ratify Data Protection Convention 108 Plus and implement the principles contained there through domestic law without undue delay, paying particular attention to immediately implementing those provisions requiring safeguards for personal data collected for surveillance and other national security purposes. I will leave it at that. Thank you.
Okay, so thank you very much, and thank you very much to our panel for keeping pretty much to time there, making my job much easier. So I'd like to open the floor now. Do we have questions or comments from the floor? So at the front, and then the lady there. We'll take those two, and then so yes, you, and then you next, and we'll take those two, and then. Get some
Hi, Pat Walsh, Privacy Matters. I've got a question for Sonny, and it might link to Patrick as well. So. Thank you for a great presentation, by the way. In Malaysia in 2013, the Malaysian Communications and Multimedia Commission, MCMC, issued an order against all telecom operators to establish an IMEI database, ostensibly to help deal with the theft of mobile phones. But it's a backdoor to mandatory SIM registration. So what it requires is for all mobile operators to send the following data to this database, so your name, your national identity number, your address, your billing address, your mobile phone number, the IMEI, which is electronic serial number embedded in your mobile phone, your SIM number, the number that's embedded in your SIM, and also the MAC address of your devices. That has to be sent to this database within 24 hours. And if any changes are made to that information held by a mobile operator, it has to be sent to the database within 5 minutes. Ostensibly, it's a surveillance tool. So I'm just wondering then, in terms of Malaysia, you have a Data Protection Act, and in terms of what you presented, in terms of viability of the person, the home, etc., and a device being extremely personal, how does that sit within the regime, and how does it sit in relation, say, to, say, Article 11 of 108 Plus? Thank you.
We'll take a couple of questions and then.
Hi, thank you so much. I wanted to ask a question about smart homes.
Could you identify yourself first?
Oh, sorry. My name's Catherine Pratt. I'm a PhD candidate from the University of Washington. So I'm wondering about the adoption of things like smartphones or Alexa or Siri or Cortana. We're seeing in the United States cases where police are subpoenaing from tech companies the records from Alexa devices. There was recently a case where someone was asking about Fitbit data to see where they had been at the time. Is this sort of stifling the adoption of these devices and smart homes as a whole, the ability to look in the home and see how many people are at home based on how much electricity you're using, et cetera, et cetera? Thank you.
Okay, thank you. So two quite linked questions there about the effect of technology on these conceptions and how that's been dealt with. So, Sonny, you were more or less explicitly asked, so if you want to start, and then if others come in after that.
Right. We have two different things here. First is how many laws and legislations are indeed inspired by rules from the Sharia, and they, to some extent, have been included. But we need to understand here that Malaysia has its legal system where the law is made by parliament. And if there's any law, any part of the law that people see inconsistent with some rules of the Sharia, it does not give way to people to simply challenge to the court and for being unconstitutional. It's only unconstitutional if it is considered unconstitutional by the court, which is the highest court, using or referring to the principles of the constitutions. So to some extent, we can see some inconsistencies there. Indeed, we say that privacy is very much upheld and recognized in Islam as a matter of principles. But when it comes to legislations, we still have to see what the parliaments have decided. So in the context that you come from, that you have given us in your question about the registration of all this personal data from the communications industry, certainly whichever regulation, whichever data that had to be regulated, that had to be recorded, at the same time, it still has to be protected by the providers. So the providers are accountable for those data that they are recording. But of course, this is not an easy matter because to say the truth is that we have a very huge case, a massive leak in Malaysia, which was only revealed last year, early 2018, and not very good thing to know, but it is the truth that there has been a leak of more than 35 million subscribers data of telecommunications in Malaysia. It has been leaked online. And it has gone through some investigations, and I heard that even the government considers it as a national security issue, but it has been almost a year, but we haven't heard. At the same time, there is a civil action, actually, some individuals suing the governments, especially the agency which were responsible for this telecommunications data in civil courts, but then this person recently withdrew the civil action because this person was a politician. When he brought the civil suit, he was an opposition member. And after election, he became part of the government. So he said, we find other ways to solve it. So he withdrew the civil action. Otherwise, it would be among the first very important and interesting precedents that we want to see how people can enforce their personal data rights using the civil action. So that's the situation, and I agree with you, a lot of things are not really put in ideally speaking, yeah, but we are working towards that.
Okay, so anybody? Yep. Well, should we let someone else come in? You can come back later on the second question, but we'll let others, if they have anything relevant for the first question, or if they want to come in on the second issue about smart homes and how that might come into things.
Let me just continue a little bit about the second question about smart homes, all these devices. We don't really have issues yet or in courts, but there's an interesting case in 2011 where someone was suing his neighbor to dismantle the CCTV, like similar like some of the cases in Morocco we see. It was the first case that a person was complaining against his neighbor for fixing a CCTV which was directed towards the entrance of his home. So, and the High Court decided that it was privacy intrusive. It was intrusive, and this CCTV was to be dismantled, and this became one of the new precedents for us when it comes to home privacy in Malaysia. Anyone else?
No, I think the issue with these is that these devices are still yet a little expensive for many of these countries, and people are already spending what money they have for devices on their smartphones, and there's less of a take-up, I think, so far. But it's definitely, I think, something that needs considering by scholars of Islamic law in terms of how the smart home will fit together with these conceptions of the very strong protections of the home in the Quran. So we've got other questions? Yep, the back there.
Hello, my name is Abdelrazak. I'm a Moroccan lawyer and now a data privacy consultant at a French consulting firm. As you know, the rights and obligation in the Islamic countries may differ according to the madhab school of Islamic jurisprudence being followed. That implies, for example, for Morocco, who follow the Maliki madhab, the Maliki madhab excludes the heirs from the testament, and the testament is limited to 1/3 of the entire legacy. Therefore, the right to decide of the release of data after the dates, as stated in the French law, will be considered as unconstitutional in Morocco. So my question to Mrs. Penninckx is do you have studies on privacy, not only according to Islamic, but according to the madhab of the countries? And another question to Mrs. Nighat. I found it very interesting that in Pakistan, women who wear purdah were the right to protect their privacy is respected even by the court. My question is to know if a man wears a purdah, can he benefit from this right to not to? That's it. And thank you in advance.
Okay, so Yassine, do you want to take that one first and let Nighat think about that one for a moment?
Okay, thank you. I want to stress on something. In Morocco, and I think it's the case in the majority of the other countries, whether they are Muslim or no, their laws, they are inspired from the principles of the Convention 108 and from the ancient, the directive, European Union directive. And what we have tried in this panel is try to say that some of these principles, they exist in the Islamic, but as far as I know, if I talk about the Moroccan law, it's not inspired from the Islam. It's inspired from the Convention 108 and the directive. That's why, as a regulator, we haven't conducted any studies regarding this issue. I've done this research when I knew that I had to attend this panel, and less for the Maliki madhab. Donc, thank you.
So I guess I'll respond to it as a feminist. I feel that the countries like ours has a it's a very patriarchally ingrained country where men have been benefiting from the unjust systems, and also even when it comes to interpretation of Quran or Islam, how many men scholars who have been interpreting this for the woman in this society? We will find very few women scholars who are out there interpreting Quran or Sunnah for the rest of the society. So I feel that I'm not sure, I haven't heard anything about the pardanishin men in this society, but I feel, specifically in Pakistan, but I feel that there is one, I don't exactly remember the verse, but somewhere it said in Quran that men need to lower their gaze. So, you know, when it comes to men's parda, it basically to stop the harassment in the public sphere, it actually stops the man first before asking the woman to observe parda. So I think from that perspective, I feel that coming from a patriarchal society, the Islamic norms have been interpreting by the men scholars for the benefiting of their own self instead of the society at large, equally.
Okay, so as you've heard, we've had the bell. So I just want to make one comment myself on this, and then I'll pass back to Elizabeth for her to sum up for us. I find it very interesting that when you do look at the Quran for inspiration for how to explain privacy, as Yassine says, many of the inspirations for the actual laws are coming from GDPR and Convention 108, but in explaining privacy laws and justifying them to your populace, of course, reference to the Quran is going to be very influential. in Muslim majority countries. It's interesting to me actually that you end up with some of the same bases as you get in America, where a large portion of American privacy law is derived from the concept of the inviolability of the home and the Fourth Amendment against the right to unreasonable search. So it's an interesting parallel there that you have this physical concept of your home being your private space is where many of these social concepts of privacy seem to be coming from. So that's my final takeaway from that, but I'll pass over to Elizabeth for her final words before we finish.
Thank you very much, Andrew. Well, I hope you found that as fascinating as I did. Not only did we have a description of, the relevant chapters inside the Quran, but we also had a journey not just through countries, but also over times from the 7th century through to the modern day and possibly into the future with Convention 108 plus. So would you please join with me in thanking our moderator, our speakers, but also to CPDP, who chose to put this panel on today. It was, I think, an excellent theme, and one that I hope we'll see more about belief systems and religions in the future, how that impacts upon privacy and interpretations and its sort of significance, if any, to law. So please join with me in thanking you, and also to the audience.